Welcome. Good afternoon. I'm David McKinley. I'm the president of McKinley Carter Wealth Services, and I'm pleased to welcome you to another of our FYI four-year investment series. Today's is a webinar, and it's a new addition to our FYI effort, and we hope you find it worthwhile. As FYIs are part of our ongoing communication with clients, we host webinars, we'll distribute email updates, and through other media, let us know about topics that you think we should be addressing, anything in the future. Today, we're going to focus on the CARES Act and the impact on your qualified plan, but don't hesitate to post questions on other related topics. The CARES Act. Just thinking about what's happened in the last 2 months, I said reflect back to Valentine's Day, which seems like years ago. Could we have imagined that we would be in the situation that we are today, with social distancing and stay-at-home orders, an abrupt and overwhelming economic downturn, unemployment of 25 million people, 15 to 20% of our workforce? Clearly, the passage of the CARES Act was significant. It was designed to have an immediate and positive impact on employers and families throughout our country. Today, we're going to address how these changes affect qualified plans and ultimately help your participants and their families. I'm joined by Monica Garber, who's a financial strategist with more than 30 years of experience and valuable credentials like the CPA and CFP, and she's as enthusiastic and passionate about care for ERISA plans, sponsors, and participants as I am. But neither of us, we don't work alone. We are serving clients, and we share this enthusiasm for caring for employers and small plans. We do this with quite a crew behind us. In fact, roughly 500 years of professional experience across roughly 40 employees based in West Virginia, Pennsylvania, and Maryland. Among the advisory firms in the country, in fact, we're among the top 2 or 3% as far as size. And we provide investment management services to, of course, qualified plans, the reason for our call today, but also to individuals and families and nonprofit advisory services. And lastly, thinking about the overall firm, I'll just say that we've been designated and recognized for excellence in a variety of ways. One, as it cares for our clients by CNBC, the international news channel. Number 2, by an industry publication as a great employer. And then thirdly, by the Center for Fiduciary Excellence as it relates to our work with retirement plans. Retirement plans is a significant part of our firm, and I'll just close with this, is that we do phenomenal things through our wealth management division, but it's virtually impossible to deliver all these services to all the individuals we come across. So helping think through, like, what are the ways we could do this? So we thought about the Retirement Plan Services Division. Almost 20 years ago now, we set this up, and essentially it has become the vehicle through which we cost effectively deliver investment management services and tools to thousands of people in each of the communities where we live and work. It's been exciting. We do a lot of great work. I know that, of course, you're a client of ours. We're happy to have you here today and look forward to working with you for many years to come. Today, again, we're here to address concerns and invite questions. Throughout the session, we invite you to pose questions through the chat box. I believe on the right-hand side of your screen, there's an option. We'll prompt you here in a minute, and we'll address as many of the questions as we can at the end of the session. So with that, Monica, I pass the baton to you.
Thank you, David. So by now, you've all received an abundance of information from your respective record keepers relating and pertaining to the COVID-19 CARES Act provisions, primarily distributions and loans. The purpose of us sharing this information today is that we want to make sure you know that we are here for you at McKinley Carter to help you navigate through the CARES Act and to basically, act as your quarterback, as we always have. We also recognize that you are all under a lot of stress and have a lot on your plate right now, whether it's, applying for the SBA loans or just trying to function within a COVID-19 environment. So our hope today is that we cover, major questions and key points that might be on your mind as it relates to the CARES Act. The goal here is not to make you an expert in the CARES Act, but to really hit the highlights and the things that we're seeing out there as we solicit questions from you, our plan sponsors. So we are pleased today to have with us Diane Barton. Diane is a collaborative partner of ours. She is here to share her expertise, insights, and information with you. So take it away, Diane.
Thanks, Monica. So as Monica mentioned, thank you for everyone being here on this presentation. We wanted to give you an overview of some of the specific retirement plan provisions of the CARES Act. There's lots of information in the CARES Act, and there's some important pieces that affect your retirement plan or the retirement plans for your employees. So we wanted to kind of just get right into it and talk about some of the main provisions and the impact that those are going to make for you in your retirement plans. The first one we're going to talk about is the temporary suspension of required minimum distributions in 2020. So the IRS has allowed participants who are in their status of receiving required minimum distributions to suspend those distributions for 2020, and that would apply to both retirement plans as well as IRAs. So if you had been required, or you had a participant who was required to take their minimum distribution in 2019 and that was paid to them in 2019, that would not be covered. However, it would cover those participants who were able to delay their 2019 required minimum distribution to April 1st of 2020. So those are not required, as well as the 2020 plan year required minimum distribution. If you have already received your required minimum distribution, that can actually be rolled back over into the plan or to an IRA, so you can avoid taxes on it. The confusing part of this is the Secure Act was recently issued at the end of 2019, and that made some changes to who is required to take a required minimum distribution. So it used to be 70 and a half, but in 2020, it's the age for the required minimum distributions has been increased to age 72. So if you attained age 72 in 2020, you do not need a 2020 required minimum distribution, and your first minimum distribution would be in the 2021 year. And if you are 73 or older in 2020, then you can waive the 2020 distribution and you would restart your required minimum distributions up in 2021.
Okay, great. Thanks, Diane. Let's move along then and talk a little bit, get into the CARES Act distributions themselves. And I think the one thing here that's most important is that very first bullet. Talk to us about the fact these are optional provisions, Diane?
Right. So you, as the plan sponsor, if you are a trustee or a sponsor of a retirement plan for your employees, you can elect whether you want to allow these CARES Act provisions in your plan, and you can actually pick and choose. So you could allow some, but not the others. So we talked about the required minimum distributions. Most employers or plan sponsors are waiving those required minimum distributions. So most of them are doing that, but now we get into some optional provisions which could really affect what you want to, how you want to handle your plan moving forward. So the first part is the CARES Act distributions requirement. So this is available to participants who are qualified individuals, and we'll talk about qualified individuals, I believe, on the next slide. But basically, as you know, in a retirement plan, you are really not allowed to have a distribution from the plan while you are still in service. You need to have some type of distributable event, such as retirement, attainment of age 59 and a half, termination of employment. However, the CARES Act would allow for plan sponsors to open that up for coronavirus-related distributions to qualified individuals, and they can take up to $100,000 of their account balance, not to exceed their vested account balance. And those would be for distributions that were made between January 1st of 2020 through December 31st of 2020. So it's a temporary provision that would allow the plan sponsor to turn on distributions in service for someone who is a qualified distribution, a qualified individual. And those are available from all qualified retirement plans, 401ks, profit sharing plans, 403Bs, governmental 457B plans, as well as IRAs. If you have a defined benefit pension or money purchase pension plan, those do have still some restrictions about those who can take it. So really, we're talking about 401k plans and profit sharing plans, 403B plans.
Okay.
So let's talk about what is a qualified individual, because that's going to be a big factor in determining who can take these distributions. So it is a qualified individual is determined as anyone who is diagnosed with COVID-19, or if they have a spouse or a dependent who was diagnosed with COVID-19, and it needs to be by a CDC recognized test. They also are allowing another category of qualified individual is a participant who experiences adverse financial consequences as a result of being quarantined, being furloughed or laid off from their job, being unable to work due to lack of childcare. You know, if their schools are closed, you have to stay home with your child and you cannot work, that would be a qualified individual. And so some of those things are what is going into determining who is a qualified individual. And so this may sound like a lot of people you may or may not know might be in this position, and you might ask yourself as the plan sponsor, how can I make that determination? And the IRS is saying that, and Congress is saying that the plan administrator can rely on an employee's self-certification that he or she satisfies those conditions to be a qualified individual.
Yeah, that's important. That
So
takes
there's
that burden off that sponsor. Diane, what kind of questions are you receiving regarding the definition of qualified individuals? What are you hearing?
So there has been some confusion on this issue as far as the qualified individuals. For example, we are hearing from some of our plan sponsors and the participants, well, I'm able to work, but my spouse was laid off. So am I able to take a CARES distribution because my spouse was laid off? And we're hoping for some clarification on this, but the preliminary guidance that we have is that the spouse being laid off from work would not be a qualified individual. If the spouse themselves is laid off from work and they have their own retirement plan, they would first go to them to request a distribution, a CARES Act distribution. So really on the spouse and dependents is they have to be diagnosed with COVID-19 in order to qualify.
Yeah, I can certainly see how that is confusing and raising a series of questions. So let's talk about what happens if we decide to take this distribution from a tax perspective.
Right. So just keep in mind the tax ramifications. Normally, if you would take an early distribution from the plan, there would be a 10% penalty if you're age 59 and a half, and there would also be mandatory 20% federal income tax withholding that the plan sponsor would need to take. So those are both waived. So the plan, although the distribution is taxable, the employer, it's not going to be subject to the 10% premature distribution penalty, and the 20% mandatory withholding is waived. And again, that would be for 401k plans, 403b plans, 457b plans. So keep in mind that the distribution still would be taxable. Normally, when a participant takes a distribution, they have to pay the taxes in the year of the distribution, but the CARES Act allows for that tax to be spread over 3 years. And also the CARES Act provision is also allowing that payment, that distribution can be repaid or recontributed to the plan or to an IRA within 3 years to avoid the taxes.
Okay, so what would happen, Diane, if one of the plan participants decide to go ahead, take the distribution, and they spread the tax over 3 years? So they go ahead and in 2020, they report 1/3 of their distribution, but then in 2021 they seem to have a little bit of a economic reprieve and now they want to repay it. Is that possible?
It is, yes, and that's a good point. So the taxes are, as Monica said, 1/3 of that tax, if a participant takes a distribution in 2020, 1/3 of that tax is going to be due when they file their 2020 tax return. If they end up paying paying it back in 2021, then they're going to have to, the participant is going to need to amend their 2020 tax return to show that that distribution was repaid to the plan. So there's a lot of burden, I would say, on the participant to make sure they're carefully tracking this and keeping, paying the taxes and, keeping good records so that if they need to amend their plan, if they pay it back, they need to make sure that they're doing that.
Amend their return, sure, makes sense. Okay.
Correct.
All right, so you're going to talk, because we talked a lot about the taxation. I think we sort of covered a lot of that. What about the Roth then? What happens on a Roth? If I take a distribution from my 401k Roth bucket, what happens there, Diane?
So if they take a distribution from their 401k Roth bucket, it depends if the Roth is a qualified. So it has to have been there for the 5 years before they take it. And if they take it then the earnings would not be taxable. But if they are not meeting that 5-year qualification and take it from the Roth anyway, the earnings on that would be taxable. So, keep in mind the participant does have to pay taxes on it. They don't have the 10% penalty, but it is taxable to them.
Right. And we touched upon, again, the amended return being required should they decide, to go ahead and begin some kind of repayment. So I think the other thing from an individual consideration is, we hate any investor, but particularly any 401k participant, to tap in and take a distribution during this period of time, given the volatility, if they really don't need to. As noted, we are going to be here to help the plan participants really think through the distribution strategy. We're going to really work with them, make sure any of your plan participants who decide to invoke this strategy really understand, as Diane had talked about, the tax ramifications, and really have them stay focused on the need to try to replenish or pay back those retirement assets. Because as we all know, we really want plan participants to be retirement ready when they go to retire, and a distribution, a distribution that they don't pay back could hinder their ability to be prepared in retirement. So just let the plan sponsors, everybody on the call know we stand ready, work with your participants, make sure they understand these distributions, answer their questions, and help them make the best decision for them, because some of them, they just may not have an option, and we're sensitive to that as well. And Diane, the last bullet point, so talk about multiple distributions. So you talked about the 100,000. So what do you mean about multiple distributions?
Right. So the 100,000 is the cumulative limit, but someone might decide, hey, I need $25,000 now, and that I don't need the full 100,000. So I'll just take the $25,000 now. But they may find in 6 months, maybe they don't, maybe they don't get their job back, or they do get sick at a future point in time, or a spouse would become ill with the COVID-19. Then they would be allowed to then go back to the retirement plan and say, I took out 25,000, I need to take out an additional 75 up to my vested account balance up to 100,000. So it could be more than one time that they're taking a distribution, keeping in mind that these distributions are just through December 31st of 2020.
But it seems like, when Congress put the CARES Act in place, then they're really trying to be very flexible and very attuned to what's happening, with the economy. And, as David had mentioned in the opening, just the multitude of layoffs and economic discourse that we're seeing through this period of time. Let's talk, I guess let's now turn our attention to loans. So do you want to walk us through those, Diane?
Sure. So in addition to the CARES Act distributions, your plan can also have a CARES Act loan provision. And again, this is optional. And again, this is temporary, but the timing on this is a little bit different than the distributions. This is only for loans through the next six months. So that goes through September 23rd of 2020. So again, you need to be a qualified individual to take a loan. You can self-certify that just like you can with the distribution. And normally, if your plan allows loans, the loan limit is the normal limit is $50,000 up to 50% of your account balance. That has been increased to 100% of your vested account balance up to $100,000. So that's the loan limit. So the loan limits have been increased. Now you want to keep in mind, if your plan currently does not allow for loans, then you are going to have to amend it to put the loans in. So that's just a curveball that you want to keep in mind with regards to the loans.
So it looks like the loan provisions, again, the qualifications are the same and it looks like the amounts are the same. It's just, again, the date window of the loan, as you had mentioned, is the 6 months. I was wondering what that 9/23 was, but it's the 6 months following the date of the passage of the CARES Act. Thanks for
Correct.
clarifying.
Mhm.
The one thing I think we also want to hear is a little bit about how does the loan repayment maybe differ from the distribution if we do a qualified distribution?
Right. So a loan, obviously loans, if loans are paid back to the plan, they are not taxable. So that's the benefit of having a loan versus taking a distribution. Again, keep in mind that you can still pay back that CARES Act distribution, but it does become taxable starting in 2020. If you take a loan, it's not a taxable distribution, and you are allowed, again, if you are a qualified individual, to suspend your loan payments from March 27th, 2020 to December 31st of 2020. So you get the rest of this year to not have any loan payments, and you would restart your loan payments on January 2021. And normally the rules on plan loans are that they're for a 5-year period. The loan will continue to accrue interest. It will need to be reamortized as of January 1 of 2021, and you get 1 more year to repay that loan. So instead of a 5-year loan, you can take it over 6 years. Okay, and this also applies for if your plan currently has loans and you have loans outstanding where participants are making a loan payment, and let's say they are furloughed or laid off, so they're not receiving a paycheck, they
Right.
can qualify to have their loan payments suspended.
Sort of like a loan holiday. Is that what was that?
Correct. Yes, that would be a good word for it. Yep.
Yeah. And I think that's important. Again, so if we have a plan participant, we might maybe gear them, more towards the loan because we know the loan has to be cured or has to be repaid versus the
Right.
distribution. We'd really hate to see them take that permanent distribution and perhaps not repay it and then really jeopardize, their financial retirement readiness at that time. So,
Right.
let's talk about, is this available to terminated participants? Because many of our plan sponsors today, we still have, in our plan, participants, employees that have separated from service that fulfill the greater than $5,000 rule. So we haven't deemed them out. How does it work to those participants?
Right. So normally most plans, and again, it would be based on your plan document, but most plans do not allow a terminated participant to take a loan just because it's going to be hard to kind of force the repayment of that loan. But the CARES Act allows the plan to temporarily modify their loan policy to allow loans to terminated participants affected by COVID-19.
Okay.
So that's one of the options, that if you are laying off employees or you have furloughed employees and they have outstanding loans, you don't know if they're coming back, but you can kind of at least give them a little bit of a holiday on making those loan payments and not default it right away. And then later, when at the end of 2020, you can go ahead and revise your loan policy to only allow it to active participants.
Okay. So again, flexibility, trying to provide as much flexibility to help as many people that have been affected, right?
Exactly.
So we'll go through some of those plan amendment deadlines. You've talked a little bit about that, but
Right. So we've talked about all these provisions, which Congress went ahead and said you can do all of this in your retirement plan. And again, these are optional. So I want to make sure that everyone's aware that they're optional. And the employer or the plan sponsor has to be the one to say, yes, I want to allow the CARES Act distributions, or I want to allow the CARES Act loans. The actual amendment of the plan document is not going to be required until the end of the 2022 plan year. So I think that people might say that seems like such a far off time, but really what happens is the IRS has to release the required language for plan sponsors to put in their documents, which they're not going to be working on that. I don't even think they're working full time. So probably till some point in the future. So you are allowed to comply with the rules and as you implement them, keeping note that eventually you will need to amend your plan document. So if you have a calendar year plan, most plans operate on a calendar year basis, that would be December 31st of 2022. The exception for that is if you would happen to terminate, if you have a retirement plan, and let's say in 2021 you decide, hey, we're just not getting back to normal, we do need to terminate our plan, you would need to adopt the amendment prior to the plan termination. So that's where you need to kind of keep track. And that's why, you know, you want to talk with your advisors and, you know, Monica and your TPA and just let them know this is what we're doing, because someone's going to have to keep track of this to eventually amend the plan document for those provisions.
Okay, great, thanks.
Mm-hmm.
You know, let's talk about, you sort of said, you just noted on something. You said, well, let's say maybe a company doesn't really get back on its feet, you know, and that might be the case. You know, plan sponsors on this call might be saying, what about my existing safe harbor 401k, you know, either the 3% or the 4%, you know, what can I do maybe to give my company a little breathing room till we can get back on our feet? And this would actually even apply to, you know, any of the discretionary plan sponsor contributions as well. But what about the safe harbor contributions?
Right. So if you have a plan with a discretionary feature for the profit sharing or the match, it's a lot easier to turn that off. For a safe harbor plan, it's not that easy to exit a safe harbor plan. As if you have a safe harbor plan, that's where the employer is giving a notice to the participants up front before the beginning of the year that we're going to make a safe harbor contribution of 3% of pay or a matching contribution of up to 4% of pay into your 401k plan. So you have to go back and look at your safe harbor notice, and some safe harbor notices include what is called exit language that says the plan sponsor may amend their plan in the middle of the year to suspend that safe harbor. Otherwise, if it doesn't have that exit language, then the plan sponsor would need to have some kind of documentation that they're operating at, the company's operating at a loss, and they need to, that's the reason they need to suspend the safe harbor. So it is possible, but you need a little bit of documentation. And the other thing you want to keep in mind, no matter whether you have that exit language or not, is that you do have to provide the participants with a 30-day advance notice. So it's not like you can shut it off at the very next payroll. You need to give them a 30 days and say, we're shutting it off, you know, here we are at the end of April, so we're shutting it off at the end of May or June 1st. That would be the earliest that you can do it, and you need to continue the safe harbor contributions through that date. You also need to give the employee an opportunity to change their deferrals, especially if it's a safe harbor match. They might say, well, if I'm not getting the 4% match from the employer, then maybe I want to cease my deferrals or suspend my deferrals. So you need to give them that opportunity. It also is important to note that a safe harbor plan has a lot of advantages for small employers. You know, it allows them to get a free pass on the 401k non-discrimination test, which is an annual test that looks at what participants are deferring versus what the highly compensated or key employees can defer. And so if you don't have that safe harbor plan, some of your highly paid or key employees may be limited on what they can defer into the plan. So if you're used to deferring the full $19,000 or $19,500 into your retirement plan or your 401k plan, the reason you can do it is perhaps because it's a safe harbor. If you remove that safe harbor for that year, for 2020, then you might have to go back to look at that testing, and you may not be, the key employees, highly compensated employees may not be able to make that full contribution for themselves. So you want to just make sure that you talk to somebody, again, talk to Monica or your advisor at McKinley Carter or to your TPA and say, what are the pros and cons of doing this? Is it a good thing for me to do?
Yeah, it seems like there's a lot of moving pieces. Again, many of our plan sponsors, for all those reasons, have adopted the safe harbor. So to really need to think about the change of that safe harbor plan. And Diane, remind us though, like when are the plan sponsors safe harbor contributions due? Because
right. So
we have some flexibility here.
There is some flexibility. So again, you want to turn back to your plan document, because that normally specifies when the safe harbor contribution is required to be paid. So some plan documents have that it's paid every pay period, and others have much discretion on that. The due date of that safe harbor contribution is only by the due date of the corporate tax return, including extensions. So you get to the full next year plus extensions on the corporate tax return to pay those employer contributions, but you do need to make sure your document is agreeing with that, and your document might not have, your document may have language that would say every payroll period. And if that's the case, you're going to want to take that out of your plan document. And maybe you say, well, we're going to just, we can't put it in right now, but we're going to try to get back before the end of the year and make that. So you can take a little bit of a holiday again that we talked about on making that contribution, so long as you catch up at the end of the year.
So a lot that goes into, exiting safe harbor. So, give us a call. We'll talk to plan sponsors through making that, decision. I think we did talk a little bit about the discretionary match. We had a call yesterday from one of our clients, our common clients, that they had asked, can they take a period of time, to put their discretionary match in? And so, walk us through those comments here. I think we touched upon some of these, but just remind us again what the flexibility is with discretionary matches, Diane.
Right. So again, that you have a little bit more flexibility with regard to a discretionary match than a safe harbor. So the employer or plan sponsor can say, we're going to stop, our match at this point in time. So long as you catch up at the end of the year, if you are putting it in on a per payroll basis, you would want to catch up at the end of the year, and we have this phrase that we call in the TPA world of a true up contribution, and that's just making sure that you're accounting for the match for the full year for participants who are putting their contributions in per pay. So you just need to make.
The plan document is 100% discretionary, though, Diane. Let's say, and they haven't made any match dollars at all this year, then there is some wiggle room, some flexibility. That's the point of making a discretionary match in the plan document, right?
Correct. Yes, much flexibility on that. Yep.
Okay. As opposed to the safe harbor that we just went over. So
right, and it's all what you are communicating to the participants, what you're telling them. You want to kind of make sure that you're following that.
So we talked a little bit about the flexibility being afforded to plan sponsors under the CARES Act, but the DOL isn't providing, not relinquishing, the obligation of the employer to deposit those deferrals, right? That's a very key point to make sure all of our plan sponsors are crystal clear on, right?
Correct. I mean, that's an important part to remind people of. The Department of Labor is really the government agency in charge of the participants' rights and deferrals, and you are withholding the money from their pay. So on their 401k elective deferrals and any loan payments that are withheld from participant pay, you still have to follow those guidelines that the employer needs to deposit those as soon as reasonably possible. And for plans with under 100 participants, the safe harbor that the IRS has put with that guideline is the 7th business day after they are withheld from pay. For larger plans, it's actually a little bit more strict. It needs to be as soon as possible, like payday or like 2 or 3 days later. So the Department of Labor doesn't really want the plan sponsor to use that kind of float or to use that extra, those $20,000 sitting in their bank account that belong to the employees to kind of solve their short-term cash flow problems. And that's a big compliance issue with the Department of Labor. So that's something that they really look at, plan sponsors, to make sure that they are depositing the deferrals and loan payments timely.
Yep, important to just emphasize that. Thank you.
Mm-hmm.
So, let's take some time. We talk here about opt-in and opt-out. So when we're talking about that, we're talking about referring to the information that all the plan sponsors have received from their individual respective record keepers. So some of the record keepers are what we're calling opting in the plans automatically. And others are opting out. So when you opt in, that means that the plan is sort of like a negative election. Is that right, Diane?
Correct, yes. So this is where there's a little bit of confusion, and because every record keeper, if you have, the record keeper is the party that holds the plan assets. So they're doing things a little bit differently. So some are using what's called an opt-in approach, which, as Monica said, is a negative election. So they're opting all their plan sponsors in to accept the default, and meaning, remember, it's optional whether you want to offer the CARES Act distributions and loan provisions, but they are saying, we're going to just take our whole book of business and everybody is gonna allow the distributions and loans unless you specifically fill out a form to opt out.
Right.
Okay. So you can opt in and accept the defaults. The other option is to opt out, where you reject the default, saying, hey, we're doing well, everybody's still working. For right now, we're rejecting the defaults. And if you want to allow for someone to opt in, you would have to let your record keeper know through either Monica or your TPA that you do want to allow those provisions. And again, keep in mind, you can mix and match. So you can say, we're just going to allow the loans and not the distributions, or we're just going to allow the distributions and loans. So it doesn't have to be all or nothing. And again, I just want to, remind the other considerations that, again, these are temporary provisions. So for the distributions through the end of the year, new loans by September 23rd, and the loan payment relief is through the end of the year as well. And don't forget, the last day of the plan amendment. Yep.
Right, that's good. So, I mean, for our plan sponsors on the line, Empower has opted everybody in. So unless you told Empower that you did not want to be swept in, as Diane had said, you're in. And some of the other record keepers that we work with, like Avoya, for instance, they've opted out. So unless you tell them you want in, you are not currently in. The plan is not currently under the guidance of the CARES Act distributions and loans. I did find out yesterday from Empower, however, that if you've been automatically opted in, and as we said at the beginning, your head's spinning, you're trying to get your PPP through the SBA, keep your plan and your company up and running, and you sort of miss the deadline that Empower sent to sort of say, no, I don't really want to be in. Empower is providing a form allowing you to opt out. So, again, we're going to work with plan sponsors, make sure they understand what stance the record keeper took, and validate that was the right stance for the company. And if it wasn't, fill out the required record keeping paperwork to determine which of the optional provisions you want to adopt. So I think that's super important.
Yes, and just to add, to that, Monica, as Monica said, you can change your mind. So the main thing is, if you're opting in, the participant might be going on a participant website and seeing a CARES Act distribution form. So you want to be careful if you don't want in, then you want to make sure that you opt out, because the participant might be able to go on the record keeper's website and see a form and think that they can take a distribution from the plan. And then that would be obviously an uncomfortable situation talking to the participant. We didn't really want to allow those provisions. And again, if you're taking the opt-out provision, you can say, we don't need these right now, but who knows what's going to happen in 3 months or 6 months. If there's a resurgence or whatever, maybe at that point we do want to take opt-in and allow the distributions. So a lot to think about on that.
Yeah, absolutely. And I think that, again, some of the intelligence I gathered from some of the record keeping partners that we work with is that, the participant actions to take the distributions have not been all that great. Couple thousand from Empower, and the loan provisions are even less than that. So again, we're here to work with you, make sure you understand the CARES Provision Acts, and how they are best suited, with the opt-in or opt-out, what suits you and your plan participants the best. So I understand there might be some of you that are having some technical difficulty. We apologize if you weren't able to hear the entire presentation. We will be providing a tape of this presentation if made available. But for now, this is the end of our prepared comments. So now it's your turn to put any questions to to Diane or to McKinley Carter that are on your mind regarding what we've presented this afternoon, any aspect of the CARES Act. So looking to see if we have any of those questions at this point. They're coming up on the chat box here. So one of the questions that we got sort of goes back to let's take Empower, because Empower is a record keeper that plan sponsors of McKinley Carter are working with. They've been opted in, Diane. So again, the best thing to do would be to just sort of revisit with with the plan sponsor to determine, did they want to make a change? One of the things you look to, right, if we have a plan sponsor who is working with Empower, we'd want to look at the loan provisions of the plan document right away, right, to determine, because if loan provisions aren't permitted under the current document, then that would absolutely cause a document amendment, correct, Diane?
Correct. And I think Empower's stance, now we would need to double check, but I think it was only for plans that currently allowed loans were they going to opt in for the loan provision. So your plan had to allow for those loans first to opt them in. One other thing you want to keep in mind is on that loan policy, even if your plan does allow for loans, some plans only allow for one loan at a time. So if someone already has an existing loan and now they want to take a CARES Act loan, that loan policy will need to be changed.
Yeah, that's right. We're seeing, not a lot of other questions, but is there anything else, any other experiences that you'd like to share with the group? Again, some unique situations or questions from plan sponsors that you think the group might find some benefit from at all, Diane?
Well, I think some of the questions that we are getting is, the different record keepers are doing things differently. And some of the questions we are getting is, are they being approved without plan sponsor signature? If you can allow, and now a lot of people are working remotely and don't have the availability to have plan sponsors sign things. So are you comfortable with allowing the record keeper to work with the participant? And in some cases, if you have a fully vested plan, like all of your money is fully vested, there's no vesting schedule, that's definitely an easier issue to deal with than if you have participants who are, perhaps on a vesting schedule and the profit sharing or the match might be a graded vesting schedule. You want to be careful that somebody is looking at those distributions to make sure that the vesting is correct at the record keeper, or that a TPA or someone is at least approving those distributions to make sure the vesting is correct. So that's some of the questions and some of the hurdles that we're getting, as well as the issue with down the line. We're hearing from plan sponsors, everybody's working, we're all okay now, but I don't know what's going to happen if the travel industry doesn't pick up, in the next, over the summer, because that's when we make the bulk of our business. We may need to lay off employees at that point in time. So there are some times where, there's some flexibility that you can work with the record keepers to say, now we do want to allow the provisions.
Okay. Yeah, and I think you hit on a good point. Again, at McKinley Carter, we really see ourselves as the quarterback. I mentioned this in my opening comments, so that these things like vesting. So, we want to really help all of our plan sponsors work to make sure, the CARES Act is working in the best light for their plan and their plan participants. So as Diane had mentioned, if you don't have a fully vested company dollars in there, we certainly want to make sure we're helping you coordinate with your TPA partners to make sure the outcomes are accurate. So I think it's really imperative that all the plan sponsors know, we are here, we're ready to jump in, we're ready to quarterback, and just let these provisions of this act work to the benefit of your company and your plan participants. So not seeing any other questions. Diane, any other final comments before we hand it back to David McKinley to wrap it up for us?
Well, I just want to thank everybody for listening to the presentation, and I'm sure there may be questions that you may have in the future. And I guess, you know, please feel free to reach out to Monica and McKinley Carter, and or to Metro specifically if we are your TPA. And definitely we will work with you because everyone's situation is a little bit different. And as we said, all the record keepers are doing things a little bit different. So you really have to know, you know, the inside and, you know, the inside outside of all of your plan provisions. So,
Perfect.
but thank
Great.
you.
Well,
Thanks.
with that, I'll wrap us up. Thank you. I thank everyone for joining us today and sharing our enthusiasm for excellence in caring for plans, taking care of you, of course, the sponsor, and ultimately the needs of your participants. We share this commitment. We work today and for many, many years into the future. To that end, if there are questions that you have that you didn't have a chance to post, or you are dealing with technical difficulties, please just reach out to us. It's been expressed by Monica, but any of the members of our RPS team and each of our offices, we're happy we'll quickly respond to you and address these questions. Another area of our care, so to speak, is with participants. And so today, of course, was solely around the sponsors' needs, ultimately to care for participants. But next week, we're going to host a similar webinar. This one will be more focused on investment fundamentals and what to do as a participant as you're saving and investing and planning. How do you prepare yourself through periods of volatility and make great, prudent decisions? If we haven't already, we will be sending to you an email, something you can easily forward off to your participants and encourage their engagement. We appreciate your time today. Thank you for joining us, and thank you for the trust and confidence you have in McKinley Carter Wealth Services.
Thank you, everyone.
Thank you.